Alô? Boa tarde a todos. Nós aqui do IBDT gostaríamos de agradecer bastante ao professor Jean de Goede, que a gente logo descobre, assim como Van Gogh, a gente logo descobre que a maneira correta de pronunciar é Jean de Goede, certo? O IBDT aproveita a visita do professor Jean de Goede nessa semana para poder fazer esse evento aberto que está sendo gravado e vai ser disponibilizado depois para todo mundo, sobre um dos temas mais difíceis e desafiadores da aplicação de tratados internacionais, que são os casos triangulares. E eu aproveito também para agradecer a presença do Rodrigo, que aceitou o convite de vir aqui tratar desse assunto. Eu sei que ele também é especialista em alguns desses casos e conhece bem profundamente os tratados brasileiros da jurisprudência. Vamos ver se no final aqui a gente consegue fazer umas provocações para o professor Jean de Goede. I'm most certain that we will learn a lot from your presentation today, and I'm also certain that Brazilian tax treaties present some peculiarities that will render some nice discussions. So, please, Professor Jean de Goede.
Thank you very much. Good afternoon, everybody. Personally, as a former Dutch treaty negotiator, a treaty should have something special. I mean, if you are a special person, don't ask an artist to make the same drawings as other people have already done. So there is a temptation of treaty negotiators to try to do something special too. It is a pleasure to speak to you about cases, as you may have heard, just overheard. I'm not the kind of person that can get glued to his chair, so maybe I will walk around a little bit. Triangular cases is an extraordinary complicated matter, and even the mere idea that we could cover a substantial part of it now in this limited time is an exaggeration. I will show you a number of triangulars, and I happen to see, not because I happen, because I follow everything, but just last month an article appeared from Professor Michael Lang in a periodical, Steuer und Wirtschaft, in which he says triangular cases an underdeveloped area. And there was not one case about company. That was all about triangulars in employment income. So what we are doing now is give you a bit of a taste of what triangulars can be about. And the first thing which is striking is that the first OECD model dates from 1963, and it took almost 30 years before there was a first report on triangular cases. So that says something. Why is that? Because treaties are designed to operate on a bilateral basis. So they are not constructed to deal with triangular or even more angular situation. And the other reason is that as long as there are no trouble around something, nobody cares. But as soon as it becomes a tool, like in this case of tax avoidance or tax planning, then suddenly the governments wake up and they start to deal with it. So if you have any questions or things, you can put them unless you prefer people to wait. So I will just go and talk about a few things, and it's easier for me to just walk around a bit. Hello. I like yellow stripes. It looks very nice. You know, people like me normally go out of countries because they say things that people normally don't. But I survived so far. Probably I'm too fast to be really thrown out somewhere. I'm already gone by the time they want to do that. So this is a basic triangular. That is the kind of triangular which was dealt with in this report 30 years ago. And what do we see? We see a company resident in state R, and it has a permanent establishment in state PE. And it provides a loan through its permanent establishment. So it might, for instance, be a bank with a bank branch in another country, providing a loan to a customer in state S. So we see the loan being provided by the resident of state R via the permanent establishment to the customer in state S. And that means we see an income flow, the interest paid from the state of source to the state of the PE, but basically, of course, part of the income of the state of residence of the company, because the PE does not exist. The PE is nothing. It is a tax fiction. It is not a legal entity. So even if the staff of the permanent establishment concludes the agreement to provide the loan, which is necessary for the loan to be effectively connected to the permanent establishment, this will never be a contract in the name of a PE. It will just be a contract in the name of the company, because that's the only legal entity that can do that. So what are the kind of questions which you should analyze when you look at these simplest triangular? You must look at the effects of treaty application in the source state. You must take a look at the tax effects in the country of the PE, and you must take a look at the tax effects in the country of residence of the company provided the loan. So these are the kind of things which I will analyze. I will talk about aspects of these three sides of the picture. So when we come back to the same picture and we have the question, if there are two treaties, there is a treaty between S and R, and there is a treaty between S and PE. And you see the withholding tax in the SR treaty is reduced to 10%, and in the SPE treaty to 5%. So the obvious question is, which benefit can you claim? And If you are a tax consultant, you would automatically say the 5, because you're always inclined to look at the ways to pay the least tax. However, of course, the answer is 10, because the PE does not exist. It cannot claim treaty benefits, because it is not a person, and it is not a resident, because it is not liable as a resident. So that treaty does not apply to this payment. It is the treaty between source and resident state. So in this case, one can claim 10%. Why is that possible, although the income is earned through the permanent establishment? Because legally speaking, it is a payment from the source state to the resident state. That is the reason why it is organized like that. And there have been debates, academic and other debates, whether you should give the same status to a permanent establishment. One of the reasons why this is not the case is there are no country where a PE is liable to tax on the worldwide income. And that is the kind of situation which create double taxation. So why would you give treaty entitlement to a PE on foreign income, which normally is not taxable in that country? Sometimes it is, if the income can be allocated, but not as broadly as in the case of residence. So we immediately move to the second kind of triangular. And what we now is a subsidiary making a dividend payment to one company, its parent company. But the parent company is a dual resident. So the parent company is both considered to be a resident of R1 under the laws of R1 and as a resident in R2 on the basis of the legislation of country R2. Again, there is the same question. If there are different treaty rates, which rate can the parent company claim? And there were a lot of academics, including respectable persons like Kees van Raat, who both entitlements exist. So the one which applies is the one which reduces the source taxing right most. So in this case, 0. However, that is a position which I worked with the government for 20 years. I was heading departments, which we already had dealt with. Because if there is a treaty between R1 and R2, and under the tiebreaker rule of that treaty, this company is to be a resident only of state R1, we would say that in the relation between R2, there is no entitlement to treaty benefits. Some people disagree and they say no, because that tiebreaker rule only affects the treaty between R1 and R2, those two states. But we have always taken as Dutch a different position, saying, I don't care what causes it, but once this is the case, the company can no longer be taxed on its worldwide income in R2, because R2 in that situation is not allowed to tax anything of the profits except part of the profits which is attributable to a PE in R2, if there is such a PE at all. So taken and published already 30 years ago or longer is that in this case the entitlement which exists on under the treaty between state and state. I don't know why occasionally it changes.
Ah, quer trocar pilha? Just a moment. He's going to replace the battery.
Okay. I am not running out of power. students have a bad life. They want to go to bed early.
You can continue without the microphone.
Yeah, I can. Yeah, I can.
And then I'll give you back in a minute.
So what happened in this situation? At some moment, a number of states took the same view. So nowadays, in the commentaries of the OECD model, it is clearly stated that if a company resident of a state loses its residency under a tiebreaker rule with another country, then that company can no longer benefit from those treaties. Why did the governments want to have something like that? Because they didn't want that one entity could take the benefits of multiple treaties. That is not the intention. And as I said, the taxable object in state R2, although under domestic law it is still treated as of the state, yet the taxable object is reduced by the treaty. And that is the reason why this position has been taken. I could tell a lot more about that, but we don't have time because a number of countries have also taken measures in their domestic law to deal with this, in the sense that if there is a losing situation, what I call like this, that then even under domestic law, such a company loses its status as a domestic taxpayer. But for instance, in my country, this is not the case. It's only the effect of the treaty which leads to the situation. So, as I mentioned, there is a traditional approach that you could apply the benefits under both treaty, but meanwhile, and already in 2008, the OECD clarified the situation the way I have described to you. Okay, now why did one after 30 years start to get worried about this? That's because of tax planning structures. So what was the structure? You would set up such a PE structure and provide your loans through the PE instead of directly in case there was a favorable treaty between S and R, so you could reduce the withholding tax substantially. The PE state was hardly taxing the income, and in the treaty between R and PE, R gives an exemption for the PE profits, which in a number of countries is a normal practice, which is actually a fundamental element of tax economic policy, like in my country and many other countries. If a Dutch company operates in another country, we don't want it to have to pay more tax than the same companies in that other country. If you have a credit system, you always levy more tax in the resident state if there is less tax in the source state. But basically, that is economically disadvantaging your business. Because if you are then competing with a local company, you have to make a price which includes a higher tax than your competitors. So this is never invented for tax planning. This has never been done to be an abuser of system. It is a pure sound economic policy principle to promote your companies being able to effectively compete abroad. However, if actually it's not but a little bit lower, but it is a deliberately created regime in the PE country, and if it particularly also applies in cases of passive activity, so not real active business activity, then of course it may be used as a tool to abuse and to basically shift profits to a low taxing country and not being taxed anywhere. Because in this picture, the state of source reduces its tax, so no tax or little tax, no tax or little tax in the country of the PE, and no tax at all in the resident state because there is an exemption. So, do we need special provisions for that? Well, first of all, you can challenge or look whether the PE is a real thing. is there something which is a PE? And we did a lot of fighting of construction by simply saying there is no PE. It's just a fake thing, it's no real PE. The second thing, are the people at the PE really qualified to decide about granting the loans? If they are not, you can say that the loan is not effectively connected to the permanent establishment. So these are ways how you can combat that. The OECD, they looked in the report and they said there are a couple of ways how this could be fought. One is that the resident state does not provide a certificate of residence, so you cannot claim the benefits. The other one is that the source state says in the treaty between S and R that the source state only has to reduce if it also has a treaty with the PE state and does not have to reduce more than what it would have reduced in relation to the PE state. If you would have a provision like that, you would already exclude all real tax haven because you don't have treaties with tax haven. And the third option was to think about creating a tailored provision to fight avoidance in that respect. And that is where we are now in 2017, actually in BEP 6, followed by the changes of the models, both models in 2017, and where we now have a tailored provision for this situation in Article 29, paragraph 8. I just said to the colleague in the car that I had some people saying, that is an innovative, that's an innovation. I said, please don't ever say to someone, because we concluded provision like that in our 1992 treaty with the United States, about 30 years ago. One was already knowledgeable about these problems, and there were already very similar kind of anti-abuse provision. So you can see how long it takes before there is a more general acceptance of specific anti-abuse provision, because the problem is always whether you do not create a provision which is overkill, which is not only combating abuse, but also hampering real business activity. And that's the same with the limitation on benefits and against treaty shopping. You need to do very tailored work, or in fact you are causing more damage than just fighting abuse. So what does this anti-triangular PE provision look like? It's the same picture. So you see a head office, a company with a PE, which provided a loan and receives an interest. That provision now, as proposed in Action 6 of BEPS, says that if income is derived by a resident of state R, and that income is attributable to a PE in a third state, because we are talking about the treaty between R and S, and the profits attributable to the PE are exempt in the resident state, the tax on the income in the PE state is less than 60% of the tax that would have been imposed in the resident state, that if that is the case, then the limitation, the favorable reduction of withholding tax in the source state needs not to be applied, but in this version, it meant that you cannot have your domestic withholding tax, but still a reduced rate. Why is that? If you would immediately go back to your domestic rate, why would you have a treaty with that country at all? Then it is reasonable that in the context of allocation of taxing right between the resident and the source state, that the resident state is not suddenly obliged to give a credit of 30% tax. That is the background why we negotiated with the United States such a kind of provision. And even then, even if there is no taxation in the PE state, in our treaty with the US, which sometimes positions itself as a champion against tax avoidance and planning, although a lot of these structures are developed by American consulting firms, even then, this is not applicable if there is real active conduct of a trade and business in the PE state. So in that sense, it is a rather balanced provision. At that Action 6 part, there was also an exception for the so-called royalty boxes. As you know, this had to do with this particular acceptance of a lower rate for taxation of royalties if there was substantive research activity in the country providing that benefit. So that is the provision in the BEPS thing, which is 2015, the final report. When we then take a look at the anti-triangular provision in the MLI, the multilateral convention, much to your surprise, it's not the same as the one just proposed in Action 6, because there is no fallback to a limitation of withholding tax if you don't meet the 60% threshold. Nor is there anymore the exclusion for the royalty boxes in that wording. However, as an add-on, if you don't comply with the test, there is still a discretionary power of the tax authority to yet grant the treaty benefits. So surprisingly, within a very short period of time, two quite substantially different provision. And that's not the end of it, because when the models were published, the new models 2017, much to my surprise, I saw that that provision is even deviating from the two previous ones. Because now we see that the cut-off threshold of tax in the PE state is no longer only 60% of the tax in the resident state, but the lower of either that norm or X% to be defined in the treaty of the gross income received. So there is another criterion whether you meet or fail it. Now, one problem was with the discretionary power, if there is no taxation at all in the PE state, for instance, because of compensatory losses. That was completely unclear whether you would then be treated as a tax haven. So what is remarkable is that in these 2017 models, it is explicitly mentioned that one of the reasons why governments might still want to give the benefit if the low tax is caused by the normal legal possibility of compensating losses. So what you see, and don't say that international tax law is easy, that even the same people developing these provisions within a time threshold of 2 years have made 3 different treaty provisions. I find it actually rather amazing that after 2, 3, 4, 5 years, you evaluate and you come to a different approach. I understand. But if you are standard setting in BEPS with all these partners, if you are further working on an MLI, which has now been signed by 80 countries, and almost at the same time you publish models with different wording, what should a country follow? You really need to study the differences to a treaty negotiator, and to do the things in the best interest of your country. What do you need to choose? Okay, this is the anti-triangular in the Dutch-US treaty, which is a rather refined one. I'm not going to talk about that because it's the same idea. Are you mentally still with me? Yes. Because now we go to stage 2. Because I work in an analytical way from the source, I go to the position of the last point, which I want to do, almost last point of the source state perspective. And that is situation of double source. We have already seen double residence, but now we see double source. How can that arise? The same picture, as you can see, loan provided through for instance, a subsidiary or another party, but the money is used to finance the activities of a PE, which means that the interest legally due by company S is effectively charged to the PE. This is an external cost. So even these words that you cannot charge between head office and PE is not relevant here because it is a really incurred third-party obligation. Now, which treaty applies? Because we are still looking at the withholding tax in the source state. And then when we take a good look, I think I better go back, see? Oh, I can do, no, yeah. So it seems to go one way, got it? Normally you can use this and then reverse way, but it doesn't work like this. What you can see here is that if there is a treaty between R and S, that treaty applies on the interest being paid because it is legally paid by a resident of S to a resident of R. So S is allowed to levy tax, but not more than the percentage in the treaty. When we look at the treaty between state PE and state R, and we look at Article 11, paragraph 5 of the models, a interest is deemed to arise in a country not only when it is paid by a resident, like we have in the state S situation, but also if the interest is borne by a permanent establishment in that state. So what you see here is that basically both countries are allowed to levy a withholding tax on the same interest. So here you see a potential for double taxation. And later we will see whether the resident state is then obliged to give credit for more than one withholding tax. Yes, please.
Usual situation? Because under our perspective, it's quite difficult to imagine that even if the permanent establishment is bearing the cost of the interests of the funds used, whatever, to do anything here in this state, but those interests should be paid from the state of the permanent establishment to state S. So there is a discussion on whether there will be withholding income taxation in the state of the PE, and then if there is a treaty between those states, if this treaty is applicable in this specific step.
Yeah.
Well, so it's quite difficult for us. At least we don't have any cases in this sense. So that's why I'm asking if it's.
I understand, and the answer is simple. It's a matter of your domestic law. And there is no reason from the perspective of the PE state not to want to have the withholding tax, because through the charge, basically the tax base is used PE state by the interest payment. And a lot of philosophy behind withholding taxes in cross-border situation is that you partly want to compensate for the tax deduction you had to incur. But if you don't have it in your domestic law, then the treaty may allow you to do it, but you cannot do it if your domestic law doesn't allow. Actually, when you look at the nature of a withholding tax, a true withholding tax, you would normally impose it in the country from where the cash flow occurs. If in this example, the interest is directly paid from the bank account, not of the PE, because the PE has no bank account, but from the bank account in the PE country, which is attributable as an asset to the PE, then basically you only see one income flow.
So then what you're saying is that the flow of resources will be from this country to the
Yes. But in the resident state, in the source country, they can say whether there is a real flow or not. In fact, it also reduces our tax base if they include the profit of the PE in their worldwide profit. So theoretically, it's possible, and the OECD has recognized that legitimately both source states are allowed to tax. But whether they effectively do has nothing to do with the treaty application, but it's purely a matter of domestic law. The last thing I would like to say, the treaty between PE state and S can never be applicable, because there is not one provision which deals with an internal question between the one and the other, because company S does not receive income from the PE. So that is just to clarify, because a lot of people would be inclined to say that that is dealt with in that treaty, but it is not. Okay, so that is dual source. Misery. If you are a tax planner, you must take into account whether that's going to happen or not. However, there is always the bright side of life. And that is that sometimes you can use this situation to create double deduction. And this is one example. So a loan provided to company S, and in fact the money made available to the permanent establishment, which is charged on it. And if in the country of the PE, it is possible to have group consolidation with the PE as the parent consolidating the results of the underlying subsidiaries, this is also in my country, it's possible, then basically if the PE is loss-making due to the interest charge, you can set off the loss both in state PE against your profitable subsidiaries, and because the PE is part of the company in S, if it levies tax on a worldwide basis and it has no absolute exemption, like in a territorial system, you can equally take the loss in state S. So suddenly now you see that the same situation may lead to double deduction of a loss in that situation. So don't spend too much time on the beach, because 2 years ago, after BEPS Action 2 was already finished, I was on holidays. That's why my family considers me a nerd. Because if everybody is asleep, or if they are looking the other way, I'm looking at my mobile, and in the summer, in July, the OECD published as a follow-up on Action 2, the so-called branch mismatch report. And if you look at that, then what is said is the following. Recommendation 4. We see here double deduction and only one inclusion. So then you know the approach in the hybrid mismatch thing. There is a prime recommendation of action against it, and if the country allowed to take the action doesn't do it, there is a fallback position for the other country. And in this case, you can find that situation, and the recommendation is not to give a deduction in the state of the head office. Why? Because the interest charge has been allocated to the PE, so then it's reasonable to say you don't need to also take it in the head office state. But if the head office state doesn't abolish that deduction, then it is said that the PE state is allowed to skip the deduction. Has that anything to do with treaty application? No, because this is purely potential measures under the domestic law of the country. I was a legislator. I was not only heading treaty negotiation department, but also company tax legislation. This is not easy to legislate, because if I am in the state, I would have to make a law saying that although there is a normal deductible interest, that you are not allowed to deduct it if it is already deducted in the country of residence. So a taxpayer and a tax inspector must know the legislation of the other country. And then I don't even have practical problems like timing differences. If something is not done yet in one country because, as we will see later with other examples, you might want to put the next position in, but then later it turns out that they have done it. So do you then have to correct your mechanisms which you have put in place? If you then don't revert back, you will have double taxation in the sense that there is no deduction at all, whereas there is an inclusion. So in other words, what you see here is how domestic law and treaty law interfere with each other. There is another issue which could be debatable at some stage as well, and that is that if you only deny the deduction in the PE state for interest paid to a non-resident, you may get into trouble with the non-discrimination article. So in one or another way, it must be understood that in abusive cases, apparently, you should not encounter a problem under the non-discrimination. That could be the case. I am not analyzing all the details now, that takes too much, but I just think.
Based in which legal ground?
That you would treat a PE worse, for instance, than a domestic company if you would only apply it to a PE and only on interest paid abroad. You would have to analyze more cautiously. I'm only pointing at the fact that you must take a look at it.
I think that the non-discrimination would be based on the internal provisions concerning the treatment of a permanent...
I think it's article by heart. Huh? I cannot even quote the Bible, so if you can't quote the Bible, you certainly should not be able to quote the taxes. So, but I think it's 24.4, which could lead to certain problem. Yeah, yeah. If that is not applied in a discriminatory way. I'm not saying it is the case, I'm saying it is at least a point which one should always look at, whether or not that could create. Okay. Now the next topic is the PE receives the income. But that income may have suffered withholding tax in the source state. Is the PE obliged, the country of the PE, to give relief of double taxation? Do they have to credit the withholding tax of the source state against the company tax in the PE state? Does the treaty between S and PE oblige to that? Anybody an idea about that? It would seem very reasonable, isn't it? To say the least. No, there is no such obligation because the PE cannot claim any treaty benefits. Because the PE, like we saw before, is not a person who is a resident of PE state. So the PE has no right under the treaty between S and PE to a setting off by foreign tax credit the tax levied in the source state. One would be inclined to say, okay, next problem. No, because there is a potential protection. And that protection is not in the treaty SPE, but in the treaty RPE. And there we come back again to the non-discrimination provision, because Article 24, paragraph 3 of that treaty says that you are not allowed to treat the taxation of the PE of a resident of the contracting state worse than a resident would be taxed in the PE state. So in other words, if a resident of the PE state would be able to credit that foreign tax, one has to give the same credit to the taxation of the PE if you have a treaty between R and PE having this non-discrimination provision. The matters are much more sophisticated than that, because that is an interpretation which is rather generally shared if in country PE such a credit would be granted under domestic law. Then there is no difference of opinion. But when state PE does not allow such a credit under domestic law, but only allows it to its residents on the basis of the treaty between S and PE, then we get different opinion. Then most countries think it is reasonable to also give the credit to the PE, but not more than the credit which a resident of PE could claim under the treaty in between PE and S. But other countries say this is not the case because the PE can never be entitled to a treaty to which it has no entitlement in legal sense. So the commentaries, strangely enough, in the one place when we talk Article 24, say that not everybody thinks like that, but it would be reasonable to do it, whereas in the commentaries on Article 23, it is mentioned that a PE can never, also not indirectly, claim the benefits of another treaty. You had a question.
Situations where a country offers tax credit without a particular treaty, right? And you're from the US, right?
I'm a Dutchman. I negotiated with the US.
You know, people.
They were a bit afraid of us, although we are very small.
Yeah, I read a very good article how the Netherlands Academy is practically putting Dutch aside, you know, the Dutch language aside, and using English even more and more, and how this is going to.
You know, it was one vote difference when America became independent, whether they would adopt English or Dutch as their language. Dutch lost by one vote. Okay, but that was not your question. Otherwise, you would have spoken Dutch.
Of that, the US does not have an official language. English is a de facto language, not the jury language.
But what was your question? Because I'm not a professor in linguistics.
Well, my question is, there are situations that countries offer tax credits unilaterally, right?
Yeah.
And without the necessity of a particular treaty.
That's what I was mentioning first. If you have that already in your domestic law, then 24(3) would force you to do it. Because if you would not do it, whereas under domestic law you would do it to a resident, that would bluntly violate 24 paragraph 3. But the problem I was ending with is if you don't have it in your domestic law and your resident only has the entitlement on the basis of the treaty between the source state and the PE state. In that case, that's why some countries do not agree, because they say if you then treat that the same, it means that basically a PE can get the treaty benefits of a treaty to which they have no direct entitlement. That's why there is no completely uniform view on that. The OECD recommends, whatever your troubles are, that you should try to arrange, either specifically in the treaty or in your domestic law, that you are able to give a credit, because otherwise you keep double taxation.
But in this particular scenario,
Yeah.
you mentioned there is a treaty but not recognized by domestic law, then the country can refuse giving the credit, at least in theory. Sometimes.
Some countries take that view. These are countries which are very formalistic and apparently don't care what treaties are intended to do. I put it a bit blunt now, but then I'm rather clear.
Otherwise, by signing a treaty with state, with the state, with the PE state, you then have access to all the treaty network of that.
Yeah, but not to all the benefits, of course. We are only talking about this very specific thing, And even you cannot get more credit than that a resident under that treaty would have been able to get. So if the treaty between S and R allows 10% withholding tax, but the treaty between S and PE would be 5%, then you can only claim on the basis of the non-discrimination a credit of 5 and not of 10. Because if you would then give 10, you would treat it more favorable than a domestic company, which is never the idea of a non-discrimination provision. Any further questions on this? Okay. If you still have, you can join the classes this evening and have a second try, if the students let you in.
Yeah, I'm a professor of linguistics, but a professor of international law. That's why
Very good.
this issue of treaties interests me.
No, but your question was completely valid. I only always try to be rather outspoken and clear in my answers. To be a bit lively, you know, otherwise everybody falls asleep. Actually, I'm always hesitant to give real complicated presentation in Amsterdam, because after my classes, people have to go back to their hotel. And you know how many canals we have in Amsterdam. Some people get so totally disoriented that they would walk into any canal they can meet. If you really have the whole picture, huh? Because we only deal with a part of it. I would throw in also triangulars with employment income, etc. Okay. This is the explanation of what I just said, so I'm... Okay, then we see again a kind of tax planning abusive structure, also with a situation in a source state and a PE state. So what do we see here? This was practiced for a number of years. I doubt whether it's still possible, because I think the Irish changed the law. A Cyprus company wants to provide loans to its affiliates in all kinds of European countries, including Portugal, for instance, including the Netherlands, etc. But they do not provide the loans directly, because if they would do so, there would be no withholding tax, either because of the treaty or the EU directive on interest and royalty, but the interest would be fully taxed in Cyprus. So what do? They organize the financing via establishment of a financing branch in Ireland. So a loan is given through a financing branch in Ireland, and the interest is thus paid by the affiliates to the bank account and effectively connected to the branch in Ireland. What is creating the problem? The same picture, no withholding tax in the source state, but Ireland, if you have a one-off loan, does not consider that to be a PE, even though there is an office. But if there is no repetitive business, they do not treat it as a PE. There is no degree of permanence in the activities. But Cyprus, under its own law, under its own domestic law, does see a PE, and they do apply the exemption system. So no taxation source state, no taxation PE state, no taxation resident state. I am just a simple economist and a tax lawyer. I am not a linguistic person. I'm also not a geographist. But it reminds me of the Bermuda Triangle. Do you know what that is? As a shipping nation, the Netherlands, we know about these things because in the past our ships used to disappear there. And here you see the same, but now it's not a ship disappearing, but taxable income. Because suddenly there is no taxable income anywhere. So this was possible for many years. But again, if you spend your holidays in July 2017 well, still reading your tax literature while on the beach or walking in the mountains, then you could see that also there is now an approach to say what we see deduction and no inclusion. So this should be remedied. And like the other, there is a recommendation here to say, recommendation 1, Cyprus should not give, under its domestic law, the exemption if there is no PE in Ireland. That's step 1. Step 2, if Cyprus doesn't change its legislation, then the countries of the affiliates are allowed to no longer allow a deduction for the interest paid. Again, this is not treaty law, this is domestic law recommending the countries to put an end to this situation of deduction, no inclusion. Very difficult to read. I got this branch mismatch report, I got it with me. This evening to the students I will show it. That report is 100 pages of complicated structures. So if you would really read it during your holidays and you have or had a relationship with someone else on holidays with you, probably you don't have that problem anymore afterwards. Good. Now, what we have been looking at systematically is problems from the perspective of source state, problems or questions relating to taxation in PE state, and now we have the issue of the resident state. The resident state, which could leave tax avoidance if it applies the completely bona fide exemption method. So what we have been focusing at so far is approaches where either the reduction of the withholding tax is denied, or we look at the treatment in the PE state. But one of the other options to solve the problem is for the resident state to switch from the exemption method to the credit method. And that's what the Germans started to do, because they're also an exemption country, and they called the switch over clause, to say it in good German English. The switch over clause. Now, if you are only reliant on your domestic law, you can do what you want. But if in the treaty between R and PE, you have in the treaty an exemption for PE profit, you cannot do a switch over, but you have to change your treaty to enable that. So that could be a matter of treaty law, that you have to change your treaties. Good. Do you have the stomach to look at this example or not? Mr. Chairman, how are we time-wise? Okay. Because once I start to talk about my topics, I am living in a timeless zone. I don't want to look on my watch. And if I would, it would make no sense, because I kept this one on Dutch time, so it's 9:10 in the evening now. Okay, so this is a simple example how a switch over clause would work. So we have a head office, a company, providing a loan through its PE in the PE state, and let's say that in the source state the payment of 100 interest is made, and that the domestic law has a withholding tax of 30%. However, there is a treaty between S and PE, 5%, and between S and R, 5%. Now, we have already discussed that what is applicable in this case is the treaty between S and R. So, state cannot levy 30%, they can only levy 5%. Now we move to the country of the PE, and I assume they only have 10% company tax, which is 1/3 of the level, 60% like we talked in the past, but only 1/3 of the level of state R. They receive 100 income, gross. Their tax would be 10%, they would have to give a credit of 5, not on the basis of the treaty PE and S, because PE has entitlement, but under the non-discrimination provision we assume between state R and state PE. So the tax effectively due in the PE state is only 5. Now we go to the resident state. The resident state, we assume there is domestic profits of 100. This foreign interest, foreign income is also 100. So the total income, worldwide income is 200. They have 30% company income tax, so they levy 60 tax on the 200. And if they give credit, the maximum credit they would provide is 30, because that is the ordinary credit which does not exceed the level of tax which they can levy themselves on that foreign income. But they give, and they don't need to give 30 credit, because they only need to credit the tax effectively levied. So they must give a credit of 5 for the PE, credit of 5 for the tax levied in the state. So if they credit 10, the total tax due in state R is 50. So my quick question to you, how much is the tax if there would not be a switch-over clause, but the exemption method? 30. Yes, because then under the exemption method, they wouldn't tax anything of the 100 foreign interest income. So you see that in this case, the low tax planning, the planning of having low tax in the PE state is completely taken away by additional tax of 20 in the resident state. So that is the effect of a switch-over clause. But as I mentioned, if there is an exemption in the treaty between R and PE, you cannot do it unless you change your treaty. Any question about this? Can I put the question to you? Can the two systems work at the same time? That both the source state applies the anti-triangular to not have to reduce its tax, whereas the resident state applies the switch-over clause. That would be nice. Then we got a nice mess. Huh? No. Because the anti-triangular says that you can only apply it if the resident state applies the exemption method. So if it's the credit method due to the switch over, the anti-triangular provision will not work. Again, we may have trouble of timing difference, because in the source state, they take that decision at the moment that the amount is paid. But the decision, of course, the legislation should already be clear, the treaty should be clear, but at the time they take the measure, maybe no assessment has yet been made. And if there would be, say, margins of interpretation in the switch-over clause, you might theoretically imagine that there could be mismatches. But theoretically, in principle, there should not be, in that sense. Okay. What is the nature of people? The nature of people is that we are greedy. So we don't just want to have a bit of something, we want to have more. So, and we were confronted in the Netherlands with this greedy feeling of some people that actually do not want to pay less tax, but actually want to get tax back, even in the same circumstance. So we were confronted with a situation where we had an exemption system in treaty between R and E, and we had a credit system in what is normal on passive income in our treaty between S and R. And what the taxpayer claimed is both. So on the basis of the treaty between R and PE, that the foreign income would not be allowed to be taxed at all in the Netherlands, but that beside that, the Netherlands would have to give a credit for the tax levied in the source state. And one of the countries involved in that mess was Brazil. Because the Netherlands has one of the worst treaties ever concluded, and the Dutch treaty negotiators would not have liked to have this treaty, but for political and economic reason, that treaty was concluded. And in that treaty, there is even a tax-sparing credit. So there is even an obligation to pay, to credit Brazilian tax, which was not levied. So what the taxpayer in this case wanted is that this full foreign income, coming in this case from Brazil, Mexico, and Italy, which was attributable to a PE in Belgium, where they hardly taxed it. They had a privileged regime in Belgium for financing company. But the Netherlands had to exempt that income under the treaty between Netherlands and Belgium. There was no switch over clause. So what the taxpayer claimed, Netherlands is not allowed to tax the foreign income, but it has to credit for the tax levied in Mexico and Italy, and even the tax-sparing credit, which was never payable, of course, in Brazil. What would the result be if this would be allowed? Or if this had to be allowed, as people say. They say, I'm sorry, you concluded two treaties. The one is exemption, and the other is credit. You must honor both obligations. So what would be the consequence if you would have to do that? Credit against your domestic tax base. So in other words, that taxpayer didn't only want total exemption of the foreign income, but even wanted to Netherlands to surrender taxing right on pure domestic income. That was a case in 2007 for the Dutch Supreme Court, followed by a second attempt to do that a few years later, which I call an example of extortion by a bad tax consultant. Sometimes taxpayers complain that the government asks too much tax. I dare to say that some tax consultants are worse than governments because they charge for procedures which are chanceless. And the taxpayer has to pay for the litigation. So I think the second time is very bad that a taxpayer had to pay a consultant for something, if the consultant would have done work, was chanceless. But that's another issue, you know, how that could be dealt with. So fortunately, we have a sensible Supreme Court. So the Supreme Court said in 2002 and 2007, the tax treaties with the third states, so Brazil, Italy, and the other one, would require to provide a credit in the Netherlands for the tax paid in these states, but only to the extent that the income for which the tax is levied is included in the Dutch taxable base, so-called ordinary credit in those treaties. And if for whatever reason, whether it is either domestic law or the operation of another treaty, you cannot tax that income in the Netherlands, the ordinary credit needs to be interpreted in such a way that you have no entitlement to such a credit. So, but this is the interpretation of a sensible and knowledgeable Supreme Court. With which words, I do not want to suggest that there are Supreme Courts in our country that may not be knowledgeable enough to do an interpretation like that. And that might allow both an exemption and a credit. This is a final treat, but I'm not going to give to you. So I think I have done my best, because that is a very peculiar case as well. But I think I have served you enough, also given the time frame we have. So I give the floor back to the chairman. If there are any questions, I'm happy to answer.
Thank you very much, Jan. I might say that I myself learned a lot from listening to you, and this happens all the times that you are here. We're happy to receive you once again in São Paulo, and I'm pretty sure that the students having these classes at the end of the day will also be excited with the information. I would like to pass the word for Rodrigo, who's going to comment on some of the case law that we have. And later on, I'll also share some thoughts on this matter, particularly focusing on interest in the wording of the Brazilian tax treaties that I think that are really interesting to discuss.
Well, thank you, Victor, for the invitation. And thank you, Professor Jan, for the very interesting presentation on the triangular cases. Of course, as Victor, for me, it was a very elucidative presentation, and we learned a lot. Of course, we have some peculiarities. The fact that we don't have a permanent establishment framework in Brazil brings us let's say, room for discussion, but in a theoretical way. What I would like to explore here is the case that we had in the past, the Volvo case, which is a very well-known international taxation case. I think that almost 10 years ago, I was invited to write an article about this case, and I would very briefly explain the case to you and Professor Jan, and then I would like to hear from him what is his impression on the case. Basically, the Volvo case deals with a situation in which the company Volvo, the automotive manufacturer, the Brazilian subsidiary of Volvo took a loan from a Japanese bank. So a loan agreement was entered into in between the Brazilian subsidiary of Volvo and a Japanese bank called Itochu. What happens is, by the time of the payment of the interest, it was decided that the interest of the loan should be paid to a branch of the Japanese bank based in Panama. So Brazil doesn't have a tax treaty with Panama, but it was the oldest tax treaty. So the first tax treaty Brazil signed was with Japan, and according to the the Brazil-Japan tax treaty, the withholding taxation on interest is limited to a 12.5% rate, so a lower rate when compared to the ordinary rate, which is 15%. So Volvo understood that it was possible to apply the Brazil-Japan treaty, so the Article 11 of that treaty, based on the argument that the fact that the interest was paid in favor of the Japanese branch based in Panama didn't meant that it was paid to a Panamanian company, but rather to a Japanese company. So regardless where the bank account of the Japanese bank is situated, it was possible to apply the Brazil-Japan treaty. And for the surprise of the company, the tax authorities challenged the application of the treaty in that case, and issued a notice of infringement based on the argument that the treaty was not applicable, so Volvo should have paid the withholding income tax at the ordinary rate of 15%. So tax authorities tried to collect the difference from 15 to 12.5, and of course there was imposition of penalties, interest, etc. So the case was ruled in the administrative field, and the company loses the case in the administrative field. So the general understanding was that the Japan treaty, the Brazil-Japan treaty was not really applied in that case. So the understanding of the administrative court was that the scope of the treaty didn't cover this situation, this specific situation. So the branch of the Japanese bank was not really covered by the scope of the Brazil-Japan treaty, which for us who study the international taxation is quite a wrong decision. So in this article, I criticized the decision by saying that the Japanese branch was an extension of the Japanese bank. Of course, it was the same thing. So it was possible to use the treaty to benefit from the treaty, and that's it. So unfortunately, it was ruled also in the judicial sphere, and the collection of this difference was maintained. So it was a very well-known case, but unfortunately with a very strange result by adopting a very polite approach. So.
Do you have a principle in tax law or international law that would apply to this case? For instance, like a territorial extension or something that could apply to this case for the tax treaty with Japan applying?
Actually, you don't need really to go that far. When you read the treaty, it's quite clear that the term Japan covers any situation in which the Japanese law applies. So the Japanese branch, even based in Panama or wherever, would be subject to the Japanese rule. So the interest at the end should be taxed in Japan according to Japanese law. So that's why the interest should be covered by the Brazil-Japan treaty. So this is the general understanding by the simple interpretation of the wording of the treaty.
Yes, but what I mean is, my question is, generally in the tax law, the application is by fiscal residency, right? Or by, what is generally the application of taxation? It's by the U.S. nationality, but it's generally by fiscal residency, right?
Residence. So branch, Panama.
We have to remember that a branch has the same legal personality of the headquarters, let's say. So
Japan in this case.
exactly. So in terms of the scope, the personal scope of the treaty, the Panamanian branch of the Japanese bank should be understood as a Japanese resident for the purpose of applying the treaty.
Maybe I can specify a bit, because if I hear that the PE should be treated as a Japanese resident, then I'm getting a bit worried. Because of the way it's formulated, what you shouldn't forget that in tax law and in international tax law, sovereign states are allowed to levy tax from residents on their worldwide income. So there is no territorial limitation of taxing rights with respect to residents. And the reason is that a resident is benefiting substantially from public goods and services provided by the state of residence. And that means that in most tax systems, in domestic law, you can tax a resident on his worldwide income. If you would not tax the resident on the worldwide income, but your neighbor has the same income, exactly the same, but only from domestic sources, then your neighbor would have to pay more tax than you because you earn part of that income abroad. And as taxes are based on ability to pay, that would be considered highly unjustified. And might, by the way, also be a way to avoid taxation in your country of residence by transferring sources of income outside that state. So there is no issue of territoriality as regards the taxation of residents. So you don't need a territorial base. The income of a branch, a foreign branch, may, according to tax law and international tax law, always be taxed also in the resident state, unless the resident state itself, in its domestic law, limited its taxing right to income derived only from its own sources. That's what we call a territorial system.
Most countries don't adopt that. I mean, most countries adopt a fiscal residency. And so, if, for instance, in Brazil, if you are a Brazilian company and you're based in Brazil and you have money offshore, you know, theoretically, Brazilian government can tax you for that money. If you leave Brazil and establish yourself abroad, then they cannot tax you for that money. Okay, but while still here, you can be taxed at home. I think very few countries adopt that principle that you mentioned on only territory. I think Paraguay does that. You know, only what you make in Paraguay can be taxed. But
actually, tax law is a very dynamic thing. One of the continents where this system was applied most was Latin America. So many Latin American countries in the past only taxed on a territorial basis. And when increasingly they got problems of rich people shifting sources of income outside their country, a big number of Latin American countries switched from a territorial system to a worldwide taxing system. So basically now virtually all Latin American countries tax on the worldwide basis, but that was not the case in the past. And as I told you, one of the problems is that if you have a territorial system, you must be very careful and take anti-abuse measures if income is artificially shifted from domestic sources to foreign sources. But there are still a number of countries that have a territorial system and that are very eager to keep it. And that means that if, as another country, you make a treaty with such a country, you should realize that if income from your country goes to Singapore or goes to other country with a territorial system, that at least there is no problem of double taxation because they will not tax the foreign income. So that is very important when you prepare treaty negotiations with another country to know whether they tax income on a worldwide basis or on a territorial basis, because that is more sensitive for tax avoidance.
I'll talk about this slide that's showing here. One thing that bothers me a lot with respect to the positions that Brazil takes with respect to the OECD Model Convention is this thing here that I'll call an anti-triangular provision, the way you put it. I feel a little lonely when I see a provision or a position like this where only Brazil. So this excerpt here comes from the OECD model and commentary, and I'm reading the session called Non-OECD Economies Positions on the 2017 Model. So normally, here's where you find the positions of all countries, and it's quite normal to see many countries taking a similar position. So I feel a little lonely when only Brazil puts this particular position with respect to Article 11. I would say it's against Article 11 in general, not only, it refers to paragraph 4 because paragraph 4 is a PE provision. But anyway, Brazil then reserves the right to provide, and Brazil does that in nearly all tax treaties except for Japan, and that's why we have the Volvo case as Rodrigo was mentioning. And I think we don't have this particular provision in the newer treaties signed with Singapore, the UAE, and Switzerland, because in those cases we have the article, the 29A8, which is quite more adequate or more complex anti-triangular provision because it's not really that broad provision. But anyway, the provision we have in nearly all treaties is similar like we see here. I'll show it in the next slide. Brazil reserves the right to provide that where interest is paid to a PE of a resident of the other contracting state. So precisely the case that Jean de Goede was presenting here right from the first slide, a payment to a PE in a third state, but the PE belongs to a resident in the other contracting state, so in the resident state. So if that situation happens, then Brazil reserves the right not to apply the treaty, not to apply the limitation on the rate. And I feel, well, I have my main question for Jean de Goede here is, and I was curious about that, whether this provision is really necessary, like, and the awkwardness of this provision is that we're here alone, right? No one else is saying that. My question is this really necessary? Like, would the permanent establishment be able to receive treaty benefit, or would the resident state be able to receive treaty benefit in such a situation? What are we trying to avoid here? Or thinking otherwise, if this is not really necessary, it seems that permanent establishment, as Jean de Goede was saying, are not entitled to treaty benefit. So a permanent establishment in the PE state would not be able to claim tax credit derived from a, let's say, PE, or taking from your example from a Panama-Brazil tax treaty. So the Panama branch would not be able to claim credits. That's natural. The PEs are not entitled to treaty benefits. So why are we saying this? Why are we avoiding the application of the treaty in a triangular situation? What does Brazil want with this provision? Is this really necessary or not? And let me just show how the provision is written in the Brazil-Netherlands double tax treaty. So you have Article 1 saying that the interest is taxable in the resident state, and Article 2 saying that the rate can go down to, let's say, 10%. And let's say we are in that particular situation. It's a long-term loan. And then Brazil says, I'm not going to let you apply the 10% limitation because interest arising in Brazil was paid to a permanent establishment in whatever country. Even though that permanent establishment belongs to a Dutch company, I don't care, I'm not going to apply the treaty. What do we want with this provision? This provision is not part of the model. We invented it, and it seems that we're the only country applying it. What do you think, Brazil?
Well, first of all, each country is, of course, entitled to have its own views and its own provision. So Brazil has the full right to ask for this. It's also the right of another state to refuse this. So if a country really has tremendous problems with it, they accept it in a treaty. Now, Brazil is not an easy country. It still takes a number of very strong source-oriented provision, And that means that maybe in the context of a compromise, an overall compromise, the other country has been willing to accept this. The fact that Brazil recognized that there may be a problem caused this provision. But I would put it a little bit in this perspective. If I see 50 people coming, and I know maybe one of them is a bad person, then either I can try to take out that one person, or I can shoot down all 50 and say, I'm sure I also had the bad guy. Now, and that is simplified how you could look at this provision. That there can be a problem is clear, because as you mentioned, the theory is, and the practice is, that the company of the resident state is entitled to claim those benefits. However, in the particular situation that that resident state operates an exemption system in relation to the PE, you might have this problem. So I would say it is a justified worry, but the tool used contains overkill. It is too broad, because if the resident country does not apply an exemption but a credit system, then basically that income will still be fully taxed in the state of residence. That's the one reason. The second thing is that even countries like the United States, which are very strict in defending their source taxing right, do recognize that such anti-abuse provision should not apply if there is a real business activity in the country of the PE. So not just for tax reason messing around with a loan, but if there is a true banking operation with banking activities being carried on, risks being taken, etc., then even in the strictest American approach, one would not apply a provision like that. And the fact that after so many years, a much more refined provision was now developed, as I discussed, shows that this provision has a very broad scope and thus would generally go beyond what countries would consider acceptable. Now, having said that, and trying to understand as much as possible the tax systems of other countries, if I am not mistaken, Brazil is a country that is very strict on always maintaining also at least tax levels of its own kind. So maybe it is a very protective approach to do this, but as I say, a lot of other countries might find this go too far and might not be willing to accept it, because it would also actually have an impact on situations where there is real business.
Just to comment on that, I think that Professor Jan understood very well Brazil. So the difference between the poison and the medicine is the size of the doses. So and we are very good on doing it wrongly. It's just for an example, our CFC rule do not rules do not differentiate between the controlled companies in tax havens or not. So it's a good example that is similar to this case.
I actually was about to give that example of the CFCs. The only point is, what you see apparently is the policy. The policy is apparently to eliminate any risk there. And of course, it is costing more effort. It takes more effort. You know, if you have a problem on your leg, then you can have two types of surgeon. The one spends hours on getting out exactly the bad thing, and the other one says, I will chop off your leg. Now, any country is free to try to negotiate what they want, from the perspective, I think, more generally of OECD country, you always never want to have forms of overkill. Why not? Because the purpose of the treaty is to promote cross-border real business activity. So if you take an anti-measure which does not really, honor treaty obligation or want to give treaty benefits in case of real business, you are actually going a bit further than what you would normally want to achieve with a treaty. But sometimes, countries take rougher measures, and the only fact to be the case is that it makes the investment climate maybe less attractive. So on the one hand, it's understandable that the government at all cost wants to prevent its own tax base being reduced. On the other hand, if you go too far in that, it may be that you get less investment. So that is a socio-political choice which each country should make, but in the OECD country, and as you have seen in BEPS Action 6 and the models, it is a more tailored and refined approach.
In Portuguese, we say using a cannonball to kill a fly, to rephrase your 50 people example. So this would
Really hate flies,
Yeah.
More tempted.
Yeah. So this particular provision in Article 11 of almost all Brazilian treaties kills any possibility of triangular cases, as we saw. But I would like to pose an additional question, both to you and Rodrigo, about Brazilian treaties, and that involves Article 11.3. We normally have Article 11.3 designed to grant an exemption of interest on the source when we're dealing with public or governmental banks or governmental entities granting loans to Brazil. So like this provision, which I picked out from the Netherlands-Brazil Double Tax Treaty, it says, notwithstanding paragraphs 1 and 2, interest arising in Brazil and paid to the government of the Netherlands or whatever, to a political subdivision, any agency owned by that government. So let's say we have a triangular situation where a company in Brazil is paying to a branch of a Dutch bank based in London, let's say, somewhere else, in a third country. In that case, Article 11.3 of the Brazil-Netherlands Double Tax Treaty says that this is exempt from tax in the first mentioned state. First mentioned state is the interest arising in a contracting state, so Brazil should not levy tax in a triangular situation, the way I'm posing here. So if I have a triangular situation involving a public bank or a governmental institution, could I then apply the treaty irrespective of the fact that I have 11.6? Because 11.6, what it does, it just says that the rate limitation provided for in paragraph 2 should not apply. It doesn't say that 11.3 should not apply. So I still can apply 11.3 irrespective of the fact that I have 11.6. I think my question is only related to treaty interpretation, but I would like to hear your opinion.
I'll assume here that in this case, the Brazilian authorities are seeing the 50 people coming, and they are quite sure that those 50 people are good people, so they don't want to create an exception for that. So, in other words, I would say that the paragraph 6 doesn't apply with regard to the provision of paragraph.
Yeah, the only question I would have to see the provision as a whole. Apparently in paragraph 2 there is a limitation to the withholding tax. And if that is the case in paragraph 2, then what it says is that that limitation doesn't apply. So it seems to be that they do want to tax, they would do want to tax in that case. Now, the only thing I can imagine First of all, is the total resentment against anything in a triangular PE case, as we have previously discussed. But the other thing might perhaps also be that sometimes state-owned companies are liable to tax, like a normal company. So, for instance, in the Netherlands, if you have a state-owned company, but that state-owned company would, for instance, be a bank competing with other banks, it could very well be that that is, though owned by the state, still a taxable entity. And if that is the case, it is not different from the anti-abuse provision which they had in the case of normal taxpayers. So that is a situation which I could imagine that they wanted to rule out, not to give an extra benefit to a state-owned enterprise if it is normally taxed. But the provision is not that sophisticated to make any such distinction. So it seems again to be a rather tough provision. Which countries are entitled to want and are entitled to negotiate, but again, depending on the perspective, what you want to achieve with tax treaty, the other state may yes or no be willing to accept that, and even if they don't like it, they may be able to accept it if they get another benefit which they consider more important. Then in the end, most treaty negotiators will put a little bit aside their own principles if you are negotiating. But sometimes these principles are very political. Sometimes you simply know that even if it is a harsh statement, that your parliament, for instance, will simply not accept a treaty which doesn't have this. And that is exactly, again, the preparation of a treaty negotiator, that you need to know how important this provision is for the other country, and then you can see whether or not you are able to make a compromise if you can show to your own parliament that you accepted a provision which you normally would not, but that you got another benefit in return for it.
Well, if we don't have any question from the audience, I think I would like to end up here. Thank you very much again, Jean de Goede, for making the time for an additional event. I'm pretty sure that everyone will benefit a lot, even our audience who's watching this online and who will be able to see it later. And thank you, Rodrigo, for accepting the challenge. Very complex cases like this. Thank you.